morning. My name is Judge Kathleen McCarthy. You are here for first appearance hearing, and there's three purposes for this hearing. The first purpose is determine if there's culpable cause for your arrest, which means that there are reasonable grounds to believe a crime may have been committed, and you are the person who committed the crime. If I find there's no probable cause for your arrest, one of two things may occur. I may give the state up to 24 hours to produce additional facts to show probable cause, or I may direct you to be released. If you're released for lack of probable cause, it does not mean the case is over. It only means that you will be released from custody. If the state wants to proceed against you on these charges, it has the right to do so. The second purpose is to determine whether you should have a lawyer appointed to represent you. You have a right to counsel. If you have your own attorney and you want him or her present, you should advise me and I will direct the bailiff to attempt to reach him or her. If we cannot reach your attorney, this proceeding will have to be delayed. If you want to have a public defender appointed to represent you, please let us know. I will appoint a public defender to represent you if you qualify for the services of the public defender. You must fill out completely an application for indigency, which will be provided to you, and the clerk of court will determine if you meet the statutory criteria for having a public defender appointed to represent you. You will be charged $50 for the processing of the application, which is due 7 days from the date of the application. Please understand the services of the public defender are not free. If you eventually enter a plea of guilty or no contest, or if you were eventually found guilty of the offense for which you are charged, then a judgment may be entered against you for the reasonable value of the public defender's services. The third purpose is to determine what type of pretrial release, if any, should be set in your case. I want to advise you, each of you have the right to remain silent under the Fifth Amendment to the United States Constitution. You are not required to say anything, and anything you say may be used against you. You also have a right to communicate with counsel, family, or friends, and if necessary, you will be provided reasonable means to do so. Edwidge Paul.
Good morning, Judge.
Hi, Mr.
Ms.
Romero.
Paul is here present. Good
Okay.
morning, Judge. Ms. Paul is here at me.
Okay, good morning, ma'am. You're being charged with aggravated battery with deadly weapon. State.
Your Honor, Ms. Paul has no criminal history. However, based on the level of violence alleged against the victim and additionally the threats to kill not only the alleged victim and their 9-year-old son, the state would be requesting a $10,000 bond in order of no victim contact, and should the defendant post bond, that should be supervised by pretrial release with a GPS monitor.
Mr. Romero.
Judge, in speaking with Ms. Paul, this is kind of a delicate situation. As the state did inform you, she's 40 years old, never had any sort of contact with the criminal justice system. The alleged victim is her husband. She resides with her husband in an apartment. They've been residing there for 2 years. She's a stay-at-home mother. She exclusively just takes care of their 9-year-old child, takes to and from school. Her husband is the financial breadwinner. She has no sort of financial resource, no sort of financial assets. Everything her husband provides for her. She's a U.S. citizen. Financially, she has no means to post any sort of monetary bond. Unfortunately, when she was arrested, her phone was not with her. She does have friends in the community that may be able to assist her, particularly, I believe her friend that also lives in Broward County may be able to provide her a place to stay. So she understands most likely Your Honor is going to be ordering a no contact. I did inform her as far as what no contact means. She's going to try and reach out to her friend to reside with her. Judge, financially, I'd ask you to consider releasing her on pretrial, even with a heightened form of supervision, potentially a level 2. Like I said, no financial resources. And as far as the no contact, I'd ask you to consider through a third person allowing contact for Ms. Paul so that she can communicate with her husband to arrange the child care and custody of her 9-year-old child.
Okay, thank you, Mr. Romero. The court's going to go ahead and find probable cause. Bond will be set at $10,000. Ma'am, if you make bond, you'll be out on pretrial with the GPS. Additionally, you're to have no contact with the victim, either direct or indirect. You're not to possess any firearms or weapons. Do you understand, ma'am?
Yes.
And to remain at least 500 feet from the victim until further court order. Good luck.
Yes, Your Honor.
Jamila Samara Brown.
Paul Ryan, Your Honor.
Good morning, Judge.
Hello, ma'am. You're being held on aggravated battery causing bodily harm, disability, domestic, state.
Your Honor, Ms. Brown's only prior was a 2004 unlawful use of false name or identity. Based on, one moment here. Based on the level of violence, and it's also alleged that by the alleged victim and the defendant's mother that this had been going on the past, I believe the past few evenings or the past few days, this violence towards the alleged victim. State would be requesting a $5,000 bond in order of no victim contact.
Your Honor, Ms. Brown has been living here in our community for over 20 years. She does have family here. She also has a friend who she believes is going to be able to post a bond, but she indicated to me that the most she thinks she'll be able to afford would be a $1,000 bond. I don't believe she has any contact with the criminal justice system. She's educated. She has a job that is starting today at 7 o'clock tonight at the airport, if she can get out and get to that job. She has lived at the same residence for the last 17 years, so she has stable residence and ties to the community. She's indicated to me that she has a friend who lives in the Melrose district of Fort Lauderdale. She can stay with that friend, so she would not have to have any contact with her daughter during this time that this case is pending. And also, she indicated to me she's looking forward to her day in court, Judge, as she's pretty adamant that there's more than meets the eye here in the probable cause affidavit. I'd ask the court to consider pretrial release for her based on her lack of criminal history and ties to the community. And in the absence of that, Judge, I'd be asking the court for a $1,000 bond.
Okay, ma'am, the court's gonna go ahead and find probable cause, and we're gonna set bond at 1,000. You're to have no contact with the victim. Do you
None.
understand? Neither direct nor indirect.
I
You're
won't.
not gonna come within 500 feet of the victim as well. Do you understand until further court order?
I understand.
Okay, and you're not to possess any firearms or ammunition. Do you understand?
Okay. Yes, ma'am.
All right, thank you, Judge. Good luck, Ms. Brown.
Thank you, Judge. Thank you.
All right. David Picard.
He's here, present, Judge at Maine.
Hello, sir. You're being held on 6 charges. The first is touch or strike battery, and 2 through 6 is probation violation or community control felony. State?
Your Honor, the state would be requesting a $2,500 bond in order of no victim contact based on the allegations, and also the fact that Mr. Picard is currently on probation for 5 different felony offenses.
Judge, I understand in reference to counts 2 through 6, he has a no bond hold. There's nothing we can do. So having said that, considering this is a misdemeanor offense, we'd be asking Your Honor to consider a $1,000 bond on count 1, and we'd also be asking you to sign a photo order so we can photograph Mr. Picard's injuries.
Okay. All right, the court's gonna go ahead and find probable cause with regard to charge number 1. Sir, your bond's gonna be set at $1,000. You're to have no contact with the victim, either indirect or indirect. Direct or indirect. Do you understand?
Yes, ma'am.
Okay? You're not to come within 500 feet of the victim until further court order. And you're not to possess any firearms or ammunition. Do you understand, sir?
Yes, ma'am.
Okay, sir, and you have a hearing on January 2nd at 9 a.m.
All right, good luck, sir.
Kirby Oxgenor.
Judge, he's here at Maine. He is approaching. He did decline the services of public defender.
Hello, sir. You're declining the services of the public defender?
I didn't hear you.
You're declining the services of Mr. Romero?
I go by who I know me.
Okay, so you are declining the services. I'll take that as that. Sir, you're being charged with aggravated assault with a deadly weapon. State?
Your Honor, the state's going to be requesting a $15,000 bond in order of no victim contact, and should he post his bond pre-trial release with a GPS monitor. Mr. Oxygenor was arrested in April of this year on 2 counts of aggravated assault with a deadly weapon. Now, the charges were dropped, but under pursuant to statute, the court can consider previous arrest, domestic violence arrest also. These were domestic violence in nature. Allegedly, he threatened his 2 sisters with a deadly weapon, stating that everybody needs to die.
Okay, Mr. Romero? Oh, Romero's not on it, that's right. All right, sir. The court does find probable cause. Bond's gonna be set at $15,000. You're to have no contact with the victim, either direct or indirect, and remain at least 500 feet from the victim until further court order. You're not to possess any firearms or ammunition. In addition, if you do meet bond, you'll be out on pretrial with a GPS.
1-5. No, 1-5. 1-5.
Okay, Brandon Cesar?
Judge, Mr. Cesar is also approaching, and he declined services as public defender as well.
Okay. Good morning, sir. You're declining the services of Mr. Romero today? Is that correct?
Yes, miss.
Okay, sir. You're being held on 4 charges. Number 1's domestic battery by strangulation. Number 2 is criminal mischief. Number 3 is resisting officer, obstruction with violence. And number 4, tampering in 3rd-degree felony proceedings. State?
1 moment, Your Honor. Your Honor, the state is going to be requesting bonds in the following amounts: $7,500 on count 1, the standard bond on count 2, $1,000 on 3, and $1,500 on count 4, with an order of no victim contact. First off, Mr. Caesar was arrested last year for domestic violence battery against the same alleged victim. That was dropped. Additionally, based on the level of violence in this case, the strength of the evidence that when he was allegedly attacking the victim, it was witnessed by neighbors who ultimately called 911, and also the allegation that he strangled the alleged victim to the point that she lost consciousness.
Okay. All right, sir. The court's going to find probable cause. With regard to charge number 1, bond will be set at $7,500. Number 2, bond will be set at $100. Number 3, bond will be set at $1,000. Number 4, bond will be set at $1,500. Sir, you're not to have any contact with the victim, either direct or indirect. Do you understand, sir?
Yes, miss.
You do? Okay. In addition to that, you're not supposed to come within 500 feet of the victim until further court order. Do you understand, sir? Hold on, sir. Let me ask you a few more questions. And you're not to possess any firearms or ammunition. Do you understand that, sir?
Yes, miss.
Okay.
Mahana, I called first the police to tell them I want this person to trespass.
Okay, sir, don't talk about the facts of this case, all right? Good luck. Marco Toussaint?
Mr. Toussaint, come on up, please. Mr. Toussaint here, President Judge of Maine.
Hello, sir. You're being held on 3 charges. The first one is touch or strike battery, domestic violence. Number 2, missile into a dwelling. And 3, child neglect with great bodily harm, without great bodily harm. State?
Your Honor, Mr. Toussaint has no criminal history. That being said, I'm going to be requesting bonds in the following amounts: $5,000 on count 1, $5,000 on count 2, $2,500 on count 3, no contact with the alleged victim, and no contact with the minor children. Your Honor, noting, 1, the level of violence, and that the alleged victim displayed multiple facial injuries and bite marks to her shoulders. That allegation that Mr. Toussaint threw a, landscape brick through the closed front driver's side window, even with his 4 children in the vehicle.
Okay, thank you, Mr. Linder. Mr. Romero?
Judge, in speaking with Mr. Toussaint, as Mr. Linder just confirmed, this is his first contact with the criminal justice system. He's 33 years old, been living in our community for about 30 years. He attended Stranahan High School. He's a graduate of Florida Memorial University. He received his criminal justice degree. He's currently working as a case manager. He's been doing that for about 11 years now, for Broward County. Judge, his father is a minister. That's who he's going to be contacting to help post his bond. From what the state suggested, a $12,500 bond is something that's going to be out of reach for his father to post. Right now, he has 4 children. He is the main financial provider of the family. Judge, we'd be asking you to consider on the first count on the misdemeanor offense, we'd be asking you, considering his lack of any sort of priors, we'd be asking you to set a $1,000 bond on the misdemeanor offense. On count 2, we'd be asking you to set a $2,000 bond. And on count 3, we'd be asking you to set a $500 bond. So the total request the defense will be considering asking you, Judge, is $3,500 on Mr. Tucson's behalf. We believe a person that his first contact with the system, strong ties to community, we believe this is reasonable under the circumstances, Judge.
Okay, thank you. Court's gonna find probable cause, with regard to all the charges. Charge number 1, bond will be set at $1,000. Number 2, bond will be set at $3,000, and number 3, bond will be set at $3,000. Sir, you're to have no contact with the victim, either direct or indirect. Do you understand, sir?
Yes, ma'am.
Your Honor?
Yes.
And based on the counts 2 and 3, we would ask for no contact with the minor children until further order of the court.
Okay, sir. And you're also to have no contact with the minor children until further court order. Do you understand that, sir?
Judge, my only question, I understand the court's concern. From what Mr. Tucson has advised me, he's the sole financial provider and caretaker. He's asking through a third party, can he arrange as far as bills, whatever needs to get paid or anything like that, he needs to still provide for his family.
If he wants to send financial support through a third party, I don't have a problem with that.
That's no problem. Financial support through a third party is fine,
Thank
Mr.
you, Judge.
Romero.
Thank you, Judge.
And also, you're not to come in contact with the victim within 500 feet until further court order. You're not to possess any firearms nor any ammunition, okay, sir? Good luck.
Yes, ma'am. Thank you.
Jeremiah Miller?
I believe he's still on loan, Your Honor.
Pardon me, Mr. Reedy?
I believe he's still on loan. He's at the hospital.
Oh, okay. Michelle Marino?
Paul Ryan. Ms. Marino would like to resolve this matter this morning, Your Honor. She's been in custody since August on other charges, but right now this is the only thing holding her.
Okay. All right, ma'am. How are you?
Good morning.
Okay, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, I do.
Okay, is anyone forcing you to resolve your case today?
No,
Are you under the influence of any type of alcohol or drugs?
no,
Have you ever been treated for a mental or emotional illness which would impair your ability to understand what's going on today?
no,
Do you understand that you're waiving your right to trial?
yes,
All right, and you're pleading no contest with regard to the obstruction of traffic, is that correct, ma'am?
correct.
I accept your plea and find it is freely and voluntarily given. State anything?
No, Your Honor.
Okay, the court's gonna go ahead and hold adjudication, take judicial notice of time served, and you'll have 12 months to pay your court costs.
Which is how much?
I think, Madam Clerk, do you know what her court costs are? $293, ma'am. Okay? All right, Lindsay Nicole Kitchen?
Thank you.
She's also in Ryan, Your Honor. This is a municipal ordinance case, but I can advise the court that she's awaiting a program on a felony, and it appears that there's nothing else other than this municipal ordinance case holding her.
Hello, ma'am.
Hello,
How are you doing today? Let's see, and you're being held on a capious misdemeanor. Mr. Reedy, does she want to resolve her case with regard to this, or how would that impact the hold?
I don't think it would have any effect, Judge. I think that really this is what's keeping her from getting into her program, but maybe Ms. Kinchin has a more insight into that than I do.
I'm actually in the program right now. I've been here since October. I'm in the life skills program at Paul Ryan, and I'm about to complete it tomorrow. So if you could resolve it today, I would appreciate it, so I could go home.
Okay, all right, ma'am, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
All right.
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No.
Are you under
No,
the
ma'am.
influence of any alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness which would impair your ability to understand what's going on today?
No, ma'am.
All right. Do you understand you're waiving your right to an attorney and to trial?
Yes, ma'am.
Okay, ma'am, so you're pleading no contest?
Yes, ma'am.
All right, I accept your plea and find it is freely and voluntarily given. State anything?
Your Honor, it's municipal ordinance.
Okay, all right, ma'am, the court's gonna withhold adjudication, take judicial notice of time served, and you'll have 12 months to pay off your court costs.
Thank you so much.
All right, good luck.
Merry Christmas.
You
Your
too.
Honor, could we call a couple cases, they're actually back-to-back, out of turn?
Yes.
I have a couple witnesses present. It's, the first case will be Demetrius Harris, and he is on page 25.
Mr. Linder, page 25 would be what
At the
part of
ver-
this pile?
Very end.
Okay.
Next, yeah.
What are the names again, Mr.
The
Linder?
first, Demetrius Harris, and the very next case, Curtis Harris. At the very, very end.
Hmm.
It's, one moment, that's, let's see, one,
I found
two,
Curtis, hold
three,
on.
four, fifth and
Okay.
fourth, all right, eight.
Just the two, correct?
Yes.
Okay, we'll call Demetrius Harris first. Pardon me, Mr. Reading? Okay. Mr. Demetrius Harris? Good morning, sir. You're being charged with burglary, unoccupied dwelling, unarmed. Charge number 2, burglary, unoccupied dwelling, unarmed. 3, burglary, unoccupied dwelling, unarmed. 4, grand theft, 5, grand theft, and 6, grand theft. State?
Your Honor, first, we have a witness present that wants to provide some information to the court.
Okay.
Your Honor, good morning. I'm Detective Chris Tran with Fort Lauderdale. My partner, Detective Tommy Vasquez.
Wait, Your Honor, if you could place, if they could be placed under oath before providing testimony.
Sure, sure. Please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay.
All right. Yesterday, we began conducting mobile hard surveillance on these two individuals who started an aggressive driving pattern going through residential neighborhoods, starting in Delray, working their way south through Boca Raton, Deerfield Beach, Lighthouse Point, where they would go to residential homes along the waterway, back into driveways, get out of the vehicle, through the curtilage, break the curtilage, go to the front door and remove freshly delivered packages, UPS packages, FedEx packages, holiday gifts that these people were counting on. They then put them in their car and they would proceed to drive around the neighborhood, sometimes in the same neighborhood for several minutes, and then they would just work their way south into Broward County. Once into Broward County, we have several confirmed victims, as you can see in the probable cause affidavit, and contact was made with them. We did a stop on the vehicle, and we retrieved several of these packages that were taken from these residences, and took these two individuals into custody. So it's my belief that keeping these individuals locked up or off the streets would benefit the general public through the holiday season.
Thank you, sir.
Now, Your Honor, state is going to be requesting bonds in the following amounts on counts 1 through 3. And because and I want to note also, because one, potential consequences is a factor the court could take into consideration pursuant to statute. Because there's allegations that Mr. Harris crossed county lines to commit these burglaries, under new legislation in the past year, there is an enhancement which would make these burglary dwellings turn these burglary dwellings from a second-degree offense to a first-degree felony. Your Honor, I'm going to be seeking bonds in the amount of $20,000 per count on 1 through 3, $5,000 per count on 4 through 6, and should Mr. Harris post his bond, pretrial release with a GPS monitor level 1. Other factors to consider, Your Honor, is the strength of the case. And as you can see from the probable cause affidavit, Mr. Harris was actually witnessed by law enforcement committing each of these offenses. Additionally, Your Honor, I've got great concern. I share the detective's concern for the threat that Mr. Harris poses to the property and the community. In addition to these offenses, Your Honor, the court should be aware, Mr. Harris was arrested December 12th in Palm Beach County for grand theft auto. He posted a $3,000 bond. Just a week later, he is now in Broward County committing these alleged offenses. Additionally, I've got great concern that Mr. Harris will not appear for court voluntarily. He has 6 prior failures to appear in court, 4 within the past 2 years. When he was arrested for the grand theft auto just over a week ago, he had warrants for failure to appear.
Okay, Mr. Linder, thank you. Mr. Romero?
Judge, in speaking to Mr. Harris, my understanding is he lives half the time with his sisters in Palm Beach, and also he lives half the time with his mother, who lives locally here in Fort Lauderdale. His mother is the person that he's going to be contacting to post his monetary bond. She is on disability. Right now, he's currently looking for employment. He's not employed at this time. He was working about maybe 4 weeks ago at a company called Northern Lights. He was making about $12 an hour. Now he's looking for work. From what he advised me, he has no sort of money in the bank, no sort of property or anything like that he owns. Judge, we'd be asking you at this time on counts 1, 2, and 3, consider setting a bond somewhere in the neighborhood about $4,000 on each count. That's something hopefully that he's going to try and contact all his family to see if they can come up with that bond amount, Judge.
Okay, thank you, Mr. Romero. The court's going to find probable cause on all charges. We're going to adopt the state's recommendations with regard to the bond. 1 will be set at $20,000, 2 will be set at $20,000, 3 will be set at $20,000, 4 at $5,000, 5 at $5,000, 6 at $5,000. If you do meet bond, sir, you're going to be out on pretrial with the GPS.
Level 1 or level 2?
Level 1.
Judge, I'd also ask you, considering that you've imposed a GPS monitor, there is a cost associated with that, $5 a day. He's not working at this time. Would you waive that cost associated with it?
Yes.
Thank you.
Curtis Harris? Yes.
Also with those, are you gonna do no firearms or weapons as they fight like the victims?
Yes, sir, you're to stay 500 feet from the alleged victims in this case until further court order, and you're not to possess any firearms or ammunition. Curtis Harris? Good morning, Mr. Harris. You're being charged with burglary on unoccupied dwelling, 2, burglary on occupied dwelling, 3, burglary on occupied dwelling, 4, grand theft, 5, grand theft, and 6, grand theft. State?
Your Honor, I believe the detective who's still under oath has some additional information, specifically with regards to Curtis Harris.
Yes, ma'am. Curtis was acting in concert with Demetrius, doing the burglaries. He was forthcoming with information, confessing what he was doing by stealing the packages from the porches. He also took pride in his fraudulent activity that he's done in the past with credit cards and things like that, and finances with, I'm sure there are several victims. His history, if you look at his criminal history, it will resemble those facts as well. So I agree as with the attorney that if a higher bond could be set for this individual, it would benefit the community.
Your Honor, with regards to Curtis Harris, I'm to be seeking on counts 1 through 3 bonds in the amount of $30,000, bonds on counts 4 through 6 at $5,000 each. And the reason being specifically Curtis Harris's criminal history. Just with regard to Broward priors, Your Honor, 2009, grand theft and obtaining property with a worthless check at a felony amount. He violated probation, was sentenced to 17 months state prison. 2008, grand theft auto and uttering forged bills, VOP 17 months. 2008, battery on a law enforcement officer, 38 months. 2006, grand theft, uttering a forged instrument, criminal use of personal identification information with the violation of probation, 5-year state prison. Additionally, Your Honor, 2011, Mr. Harris was convicted of federal bank fraud. He was sentenced to 75 months in federal prison with 5 years of supervised release. In 2016, he violated his supervised release and had that revoked and was sentenced to an additional 13 months in federal prison. Oh, and additionally, Your Honor, should he post his bond, the state would be requesting pretrial release supervision with a GPS monitor level 1.
Your Honor, if I could just, Mr. Curtis, he is the registered owner of the vehicle. And sometimes yesterday, during the course of our surveillance, he would actually follow FedEx trucks and UPS trucks throughout the neighborhood as well.
Okay, thank you, sir. Mr. Romero?
Judge, in speaking with Mr. Harris, as far as clarification, I believe Mr. Lender said he's requesting 30 for counts 1, 2, and 3. I don't know if he meant for all three of them combined or individually.
Mr. Linder?
Individually.
Individually, Mr. Romero.
Yeah, thank you. Judge, I mean, we're talking about almost $100,000 bond. That's something tantamount to no bond for Mr. Harris. He has, he's not working right now, no money in bank, no property. He lives with his mother, been residing at the same location basically his whole life. From what he advised me, his mom is also on disability. There's no way that they could come up with $100,000. Judge, I'd ask you to set a reasonable bond considering Mr. Harris' financial resources. I do understand, Your Honor, if you place him on pretrial with that added level of supervision so that Your Honor or pretrial will know where he is at all times. Judge, considering he's going to be placed, if Your Honor places on pretrial, we'd be asking you to lower the bond to something more reasonable. We'd be asking you once again on counts 1, 2, and 3 to set the bond at $5,000 each count and to leave the standard bonds in place on counts 4, 5, and 6.
Okay, thank you. The court's going to go ahead and find probable cause with regard to number 1, bond will be set at $30,000. Number 2, bond will be set at $30,000. 3, $30,000. 4, $5,000. 5, $5,000. And 6, $5,000.
And, Your Honor, as far as pretrial?
Yes, yes. Sir, if you do make bond, you'll be at on pretrial level 1 with a GPS locator. You'd have no contact with the victims, either direct or indirect. In addition to that, you're not to possess any firearms or ammunition. Stay 500 feet? Yes, and also stay 500 feet from the alleged victims. Good luck, sir.
Judge, and you said you would waive the cost for the $5 a day?
I will do so for your client, yes. Carmen Nicole Bernstein?
She's in North Broward, Your Honor. She'd like to resolve this today if possible.
Okay. Hello, ma'am.
Hi.
You're being charged with petty theft. And it's my understanding that you want to resolve your case today, is that true?
Yes, ma'am.
All right,
Yes,
please
ma'am.
raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right. Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any type of alcohol or drugs?
No, ma'am.
Do you have a mental or emotional illness which would impair your ability to understand what's going on today?
No, ma'am.
Do you understand you're waiving your right to trial?
Yes, ma'am.
Okay, ma'am, so you're pleading no contest to the petty theft?
Yes, ma'am.
I accept your plea and find it is freely and voluntarily given. Anything from the state?
Veronica Walker for the state of Florida. No, Your Honor.
Okay, the court's gonna go ahead and withhold adjudication, take judicial notice of time served, and you'll have 12 months to pay the court costs. Good luck, ma'am.
Thank you.
Victoria DeValley?
She's here present, Judge?
Hello, ma'am. Good morning. You're being held on violation of probation. State?
Just ask her to keep the bond in place.
Your Honor, the state requests that the bonds be kept in place.
All right. Mr. Romero?
Judge, it's a violation of probation. I believe your hands are tied.
Yes. All right, ma'am. Bond will remain at $2,500, and your case will be set in your assigned division, okay? Good luck.
Good luck, ma'am.
Selena Stevenson?
I've been advised she bonded.
Okay, thank you, Mr. Romero. Aaronetta Chevron Sanders?
She is still on loan, Your Honor.
Karen Bradley?
Ms. Bradley is North Broward.
Hello, ma'am.
Hi.
You're being charged with grand theft and committing theft, resisting recovery of property. Mr. Reedy?
Yes, Your Honor. Ms. Bradley would like the court to consider the possibility of pretrial release for her. She's been a resident of South Florida her entire life. She's married. She's been married for 7 years. She has 3 children, ages 8, 16, and 18. She's been living in the same residence for the past 2 years. She did attend Broward College. She graduated from Northeast High School in 1991. And she believes her husband would be able to come up with some money, but money is very tight for them right now. I don't know if she has a history of failing to appear. I don't believe that she does.
No, I don't.
State, do you have any information?
Your Honor, in 2011, the defendant was charged with attempted trafficking of oxycodone, grand theft, and possession of oxy. The state will be requesting the bond be kept in place.
Your Honor, as a result of that arrest, Ms. Bradley was sentenced to 2 years of probation, which she successfully completed, which is a further indication, I think, that she's a good candidate for pretrial release.
Okay,
Actually, Your Honor, if I may, I just need to check the notes because my system, which could be wrong, but shows something else.
No.
Don't say anything just yet, Karen.
It's fine. Nothing additional, Your Honor.
okay. The court's gonna go ahead and find probable cause, and we're gonna grant Mr. Reedy's request for pretrial.
Thank you.
Okay, good luck, Karen.
Thank you.
Okay.
Jacqueline Willoughby?
He's approaching here, main judge.
Hi, ma'am. You're being held for a violation of probation, and you have a hearing scheduled on December 26th at 8:30 a.m. All right? Good luck, ma'am.
Thank you.
Kelly Kendrigan?
Good morning, Your Honor.
Hello, ma'am. You're being held on violation of probation, and you have a hearing scheduled for January 3rd at 2 p.m.
Okay, yeah, I had a request, I was wondering, this was, a technical violation that actually the charges were dropped, the possession of heroin, it was a ticket, I wasn't arrested, it was a citation, and it was a federal, case, and it was dismissed, and the line on my report was not correct, I did write that I had contact with the police, and I wrote, will explain, and the probation officer didn't.
Okay, ma'am.
Yes, man, I was just wondering if there's any
Ma'am,
way to get
you're
released
gonna-
with the GPS.
At this time, you have a hearing scheduled on January 3rd at 2 p.m., okay?
Okay, there's no way of getting a
you-
GPS on and being released until then?
What you could do is you can ask your assigned judge about any release conditions, okay? Good luck.
Okay, thank you.
All right. Leslie Alice Schoolcraft?
So just mark PC right now. And put it, that's why you want to put it over here.
She's approaching.
Okay, good morning, ma'am. You're being held for violation of probation, and you have a hearing scheduled on January 9th at 8:30 a.m. All right? Good luck.
PC right now. Move it over there.
Charlene St. Pro?
North Broward.
Same thing with that.
Hello, ma'am.
Hello.
Hello.
Hi.
Let's see, you're being charged with petty theft as well as a warrant for violation of pretrial felony. State,
Your Honor, this is on a warrant?
we have petty theft and a
Oh.
warrant.
Your Honor, the state is requesting that the bond be set in place. This is a violation of probation,
Pretrial.
a violation of pretrial release.
Okay. All right, so the court's gonna find probable cause with regard to number 1, bond will remain at 25. And ma'am, you have a hearing set for
She doesn't have any.
December 27th at 8:30 a.m., okay?
Okay.
All right.
Is that for the violation of pretrial?
Yes.
Okay, thank you.
Okay, take care. Mallory Pierre?
She's approaching, Judge, I mean.
Good morning, ma'am. You're here for violation of community control, and you have a hearing scheduled on January 9th at 8:30 a.m., okay?
Yes.
All right, good luck. Crystal Lynn Carnes?
North Broward.
Good morning, ma'am.
Good morning.
You're being held on a capious felony and a violation of probation. So you have two hearings scheduled. One is for December 27th at 8:30 a.m. and the other one is for December 26th at 9 a.m., okay?
Okay,
Good luck.
thank you.
Janina Felicia Miller?
She's also at North Broward, Judge.
Hello, ma'am.
Your Honor, Ms. Miller indicated to me that she has private counsel. I spoke with their office. They're aware of the situation.
Okay, ma'am. So Mr. Reedy has spoken with your attorney. They're aware of the situation, and you're being held on two charges of violation of probation, and you have a hearing to address those issues on January 9th at 8:30 a.m. All right?
Thank you, ma'am.
All right,
Yes,
good luck.
ma'am. You have, happy holidays.
You too. Thank you. Leary Kennedy?
Judge, I've been informed Ms. Kennedy bonded.
Okay, thank you, Mr. Romero. Kayla Roberts?
Ms. Roberts is here present, Judge. If I could speak to her briefly for about 10 seconds?
Of course.
Thank you, Judge. Thank you, Judge.
Okay. All right, ma'am, you're being charged with grand theft, state?
Judge, she has no criminal history.
Okay. Okay, Mr. Romero?
Judge, in speaking with Ms. Roberts, as the state just confirmed, this is her first contact with the criminal justice system. She's 19 years old. She's been residing here her whole life. She graduated from high school.
Oh,
At this
Mr.
time, she's
Romero,
currently attending-
I'm sorry to interrupt you. I was just informed that her bond's been posted.
Okay.
Okay. All right, so the court does follow probable cause. Thank you. Tiana Bowen?
I've been informed she bonded, Judge.
Okay, thank you, Mr. Romero. Troy Powers?
He's in Conte, Judge. It's a municipal ordinance. He has nothing else holding him.
Hello, sir.
Good morning, Your Honor.
How you doing? Okay. All right, sir, you're being held on a capias with regard to carrying or open uncovered beverages in public. Do you want to resolve the case today?
Yes, ma'am.
Okay. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, I do.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Do you suffer from a mental or emotional illness which might impair your ability to understand what's going on today?
No, ma'am.
Do you understand you're waiving your right to an attorney in trial?
Yes, I do.
Okay, and you are pleading no contest to the municipal ordinance, is that correct, sir?
Yes, it's correct.
All right, I accept your plea. I find it is freely and voluntarily given. The court will go ahead and withhold adjudication, take judicial notice of time served, and you'll have 12 months to pay your court costs.
Could I have it transferred to civil lien? The court call?
Is this a municipal ordinance?
Yes.
Oh, Your Honor, frankly, my understanding is it can be, if at a later date there is proof of a failure to pay, then the clerk can convert it to a civil lien.
Okay, sir, that's a possibility. Just make sure you follow up, okay?
All right, thank you.
All right, good luck. Maximus Ernest?
Your Honor, Mr. McLawrence was just here. He's on his way over to the main jail to speak with one of his clients there. He's asked if the Fort Lauderdale municipal ordinance cases could be placed on recall.
Of course. D'Angelo Brim?
Mr. Brim is currently before Judge Pohl in courtroom 05150. I'd ask the court to consider resetting that for tomorrow.
Okay, the court will reset this one for tomorrow. Tarvel Dantuan Ware?
Copy.
Hello, sir. You're being held on violation of probation. State?
Your Honor, the state requests the bond be placed. Stay in place.
Okay. Anything from you, Mr. Reedy?
He has other no bond holds for violations of probation, Judge, so he's gonna have to resolve his matters before his division judges.
What are you asking for the bond for this, if any, Mr. Reedy?
Well, I mean, it's a violation of probation for a trespass, but like I say, he's already gonna be held no bond on other charges, so if you wanna set a bond, I'd ask for a $25 bond, but he's still not gonna get out.
Okay, we'll still set that bond for $25.
Well, Your Honor, that's,
Yes.
this is Judge Gottlieb's probation. He signed the warrant, he reviewed it. It's really, he's the one that put Mr. Ware on probation. It's really, he's in the position to determine what his bond should be, since he's ultimately gonna be handling his violation of probation.
Okay, so you're asking me just to refer this to Judge Gottlieb?
Yeah, I'm asking to keep the bond that Judge Gottlieb court ordered and the VOP warrant in place.
Do you know what that amount is?
He said it's on the warrant attached. He said it had no bond. Part of the,
Understand.
part of the
Okay.
reason might be, it appears he pled him out for a VOP, and then 3 days later after pleading, he pled him out for trespass. 3 days later, he got arrested for another trespass. 5 days after that, he got arrested for another trespass.
Okay, sir, so this case is gonna be reset in your division to address this, okay? With Judge
Yeah.
Gottlieb. Good luck.
Thank you.
Anthony Burnett,
If we could recall this for Mr. McLawrence, Your Honor.
is this Maximus Ernest?
Anthony Burnett.
Is that who you want me to call?
Yes, he has one in Rhine and one in Conti and one in the main jail.
Got it. Hello, are you Quentin Laverne Hanna?
He's in Paul Ryan, Judge.
Good morning.
Hello, sir. You're being held on a capias for a driving license suspended, state?
Just ask that the bond be kept in place.
Your Honor, the state requests that the bond be kept in place.
Well, Your Honor, if I could just have one more, I just want to check to see what's going on with his other cases.
Just one moment, sir.
I believe Mr. Hen is being held no bond on a VOP.
So, yeah, we would just ask, in light of that he has a no bond hold already, we would just ask that the bond be kept in place.
That's fine, Judge. He has to go in front of his division judge.
All right, sir, we're gonna keep the bond at 500 and you'll be set before your division judge, okay? Good luck.
Just wanted to get you.
Mr. Reedy, so anything that says Fort Lauderdale, I'm gonna put to the side.
If you wouldn't mind, Judge, yes.
Okay. Jericho Bryant,
Well, you could call Timothy Wright, Judge. That's not a municipal ordinance.
Jericho Bryan is here present, Judge?
And that is a municipal ordinance.
okay,
And this is a municipal in this case, a main judge.
okay, this is Jericho Bryant before me? Hello, sir, you're being held on a capias misdemeanor.
I can't really hear you. There's a lot of noise going on right now.
I'm gonna see if somebody can help us. Do we know where the reverberation's coming from? All right, Mr. Bryant, can you hear me now?
Yes, miss.
Okay, sir, do you want to resolve your case today?
Yes, I do, miss.
Okay, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Is anyone forcing you to resolve your case today?
No.
Are you under the influence of alcohol or drugs?
No, miss.
Do you suffer from a mental or emotional illness which could impair your ability to understand what's going on today?
No, miss.
And you're waiving your right to an attorney and to trial, sir?
Yes, miss.
And you're pleading no contest to the municipal ordinance, is that correct, sir?
Yes, miss.
Okay, I accept your plea. I find it is freely and voluntarily given. The court will withhold adjudication, take judicial notice of time served, and you'll have 12 months to pay your court costs.
Thank you, miss.
All right, good luck. Timothy Wright?
It's a municipal, oh, Miss Me. Mr. Wright is here present, Judge?
Do you need a moment, Mr. Romero?
I'm just looking at it. It's a capias on a violation of an injunction with a $10,000 bond.
Did I? You're,
Judge, Mr. Wright is asking, I don't think he was ever served with the injunction. Can we, Mr. Lender, verify if the injunction was served on Mr. Wright?
that's not an issue really at this point, frankly. This is from an unserved summons. The state filed the charges. The clerk's office wasn't able to serve, or whoever is responsible, BSO, was unable to serve the summons. The files was brought to Judge Brown. It's her case. She issued a capias in the amount of $5,000 per count. Because it's a court-ordered capias from the assigned judge, Your Honor, I believe those are the bonds that have to be set. The only other thing I would ask the court to do, since this is the first time Mr. Wright is appearing before a judge, I'd ask that a no-contact order be issued.
Judge, first, I believe from what Mr. Lender said, the injunction wasn't served on him.
That's not what I said.
Or the summons. He's saying that basically you can't do anything, but yet he wants you to go ahead and impose a no-contact order to modify this. Judge, at the very least, I need time to maybe talk to Mr. Wright, see if he can afford it, and if he cannot afford it, I'm going to basically be asking a similar request as the state, a modification as far as the bond amount.
Okay, Mr. Romero, I think there was a little miscommunication. Mr. Linder, do you want to just repeat?
He is correct. Yes, the summons was not served. Your Honor, the reason that the bonds need to be kept at $5,000 each is because those were and that's pursuant to the rules of criminal procedure that I'm sure Mr. Romero is familiar with. These were set by his assigned judge.
Okay.
It's also established by case law. The judge couldn't issue a no-contact order on him because he wasn't standing in front of Judge Brown when she signed the order, or the capias, setting the bonds.
Okay. All right, sir, the court's going to go ahead and find probable cause with regard to number 1, bond will remain at the $5,000. Number 2, bond will remain at the $5,000. Sir, you're to have no contact with the victim, either direct or indirect. Do you understand, sir?
And Your Honor, just for the record, the alleged victim's name, and I checked, is Myra Brown.
Okay, thank you.
Thank you, Judge.
All right, Mr. Romero, does he understand that? No contact with the victim? Okay, thank you. Sir, you're not to come within 500 feet?
10 seconds, Judge?
Yeah.
Judge, if I could have 10 seconds?
Okay. All right, sir, you're not to possess any firearms or any ammunition. Do you understand, sir? Sir, you're not to possess any firearms, ammunition until further court order. And you have a hearing, it's scheduled on January 11th at 10 a.m.
You understand? Okay.
Okay, Marcus Allen Roman? Hello, sir. Okay, there's 3 charges. You are driving while license suspended, first offense, 2, child restraint required, and unlawful speeding.
Thank you, Your Honor. Your Honor, I'm going to be just asking that the $100 bond be kept in place. I believe that's reasonable. It appears that Mr. Roman is a resident of Maryland. He currently has a warrant out of the state of Maryland for failing to appear in a traffic offense, and that was issued July 24th of this year. Also showing out of Maryland, Your Honor, also just noting, appears that there is some sort of financial resources. I don't know if Mr. Roman was driving a 2017 Hyundai when he was stopped. Frankly, I don't know if it was owned by him, someone else, a rental rented by him or someone else, but either he or someone he would be associated with clearly has some financial resources.
I have to object to that last argument, Judge. We don't know that to be true at all.
Understood.
Judge, from what Mr. Roman is advising me, he's relocated down here from out of state. He's residing out here in Broward County. From what he informed me, he cannot post a $100 bond. He's asking Your Honor if you would consider resolving his case today for time served.
State?
Your Honor, again, appears he has no ties to the community. By the outstanding warrant for another traffic offense, he doesn't go to court either.
All right, Mr. Romero, what I'm willing to do is ROR your client, okay?
Thank you.
And the court does find probable cause.
Your Honor, we have some people here on a case that was called earlier this morning, Meshach Toussaint.
Okay.
This is the case where Mr. Toussaint is accused of throwing the brick through the window with the kids in the car, and they have some information, if the court's even inclined to recall it.
Okay. I mean, we've already made a ruling, but if you want to speak.
Well, they want to speak. They have information they think might be relevant to the court.
State?
Your Honor, I have no problem with the court taking testimony from the alleged victim. Frankly, though, I just ask that it not be, or at least she be advised, if she wants to talk about any of the allegations, she may want to talk to an attorney, because it appears that she did give a statement to law enforcement already, and there could be legal ramifications for that.
Okay, so we're not gonna get any testimony right now, but if you'd like, you could follow up with the lawyer or the PD's office. Is that correct, Mr. Reedy?
That is correct, Judge.
Okay,
All right, we can do that.
all right. Yes? Pardon me?
Unfortunately, based on the amount of bond, we kind of have a small financial issue. So we wanted to know if there's any possible way. I mean, I've heard that they ask for RR, but it's not possible.
Yeah,
It could be, I don't know. But if that's not possible, is there any possible way that we could reduce? Because, you know, we kind of go through some financial issue. I'm helping out.
Okay. All right, Mr. Reedy, do we know who is gonna be assigned from your office on the case?
I do not, Judge, but I'll give these people my name and number. They can contact me probably tomorrow, and I'll be able to let them know and how to go about setting up a bond hearing.
Okay, so this is Mr. Reedy, and he will be your liaison until the lawyer gets appointed from the office, okay?
Good morning, Judge.
Hello.
Judge, can we recall 2 cases that you may have passed?
Okay, Maximus Ernest, are you on that one?
Yes,
He's-
he's from the Paul Ryan facility, Judge.
Morning, Your Honor.
Hello, sir. You're being held on 2 capious misdemeanors.
And Judge, I already represent Mr. Ernest. I previously represent him. I've spoken to him about this matter, and he desires to resolve it, Judge. The second count is a possession of marijuana count. So I was going to ask if the court would, if in exchange for a plea of no contest from Mr. Ernest, if the court would withhold adjudication and take judicial notice of time served.
Yes, I would.
Yes, ma'am.
Okay, sir, you want to resolve your case today?
Yes, ma'am.
All right. Please raise your right hand.
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes, I do.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional disorder which would impair your ability to understand what's going on today?
No, ma'am.
Do you understand you're waiving your right to trial?
Yes, ma'am.
All right. Sir, so you're pleading no contest to the trespass and possession of a controlled substance?
Yes, ma'am.
Okay, sir, I accept your plea. I find it is freely and voluntarily given. The court will withhold adjudication on both counts. Take judicial notice of time served, and you'll have 12 months to pay your court costs.
Thank you, ma'am. Thank you.
Okay. what's your other case? Is it Anthony Burnett?
Anthony Bellamy, Your Honor. It's Anthony. No, Judge. Mr. Burnett is a City of Hollywood municipal ordinance. This gentleman to my right is Anthony Bellamy.
Anthony Bellamy, Your Honor.
Hello, sir.
How you doing, ma'am?
Good, good. You're being charged with a municipal ordinance?
Yes, Judge. This particular case that he's here before you today is an open container. Judge, I represent him on a 17-8569 MO10A, and we're trying to see if we can resolve both cases. The only issue is that 17-8569 MO10A is not on your docket. So I'm not sure if the in-court clerk would be able to do the paperwork now, or if it's a matter where he'd have to come back in the afternoon, Judge.
Tomorrow? I'm sorry, what did you say, tomorrow?
Oh, Thomas Weimer, yeah.
I'm checking with the in-court clerk. Hold on.
Well,
Thank you, Judge.
could it be this afternoon, maybe? It's an MO with no paper.
Mr. McLawrence, can you please repeat that case number for the second case? For the clerk?
Yes, Judge. It's 17-8569 MO10A.
Okay, we're gonna find out with the clerk. Just bear with us one moment.
Yes, Judge.
So we can't do it this morning, maybe tomorrow or this afternoon? Okay, Mr. McLawrence, they said tomorrow they could take care of the other case. They can't do that one right now, okay?
Well, Judge, and then in that case, then, Judge, could we resolve the one that's in front of you today?
Yes, of course. Okay, sir. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Do you suffer from a mental or emotional disorder which would impair your ability to understand what's going on today?
No, ma'am.
Do you understand you're waiving your right to trial?
Yes, ma'am.
And you're pleading no contest to the municipal ordinance?
Yes.
I accept your plea. I find it is freely and voluntarily given. The court will withhold adjudication, take judicial notice of time served, and you'll have 12 months to pay your court costs.
Okay, hey Judge, I just wanted to tell you that I didn't have a warrant on another case because the police would have told me I had a warrant, but I don't have a warrant. So I should be getting out today, right? If I don't have a warrant, I should be getting out today, right?
Mr. McLawrence, do you know what's going on with the...
Judge, I don't know. I don't know what he's talking about, Judge.
Yeah, sir, I can only handle what's before me right now, and I was able to resolve this case. But
Okay.
Mr. McLawrence is gonna look into that for you, okay?
All right.
All right.
See, here's your.
Judge, there's one other matter. There's no paperwork on this particular matter. It's on page 9 of your docket. It's Thomas Weimer. And I was just hoping that we could bring him back for the afternoon docket so we could resolve it.
Hey, Jara, I don't see anything else holding Mr. Bellamy, if you want to let him know. I don't see anything else holding Mr. Bellamy.
Yes. Thank you, Reedy.
All right, Mr. McLawrence, I don't have the actual docket, so I'm not sure which case you're referring to.
His name is Thomas
Oh.
Weimer.
Oh.
It says no paperwork on the docket, but
It's gonna
they
be in
might
the
have
PM.
paperwork. Yes, Judge.
All right, we'll
Thank
see
you,
you
Your
this afternoon. Thank you.
Okay, thank
Your Honor, Conti is wondering if you could call Mr. Anthony Burnett.
Yes. Hello, Mr. Burnett.
Hello, Your Honor.
Thank you for your patience. You're being held on a capias
Yeah.
with regard to carrying open beverage in public. State anything?
No, what is it? What, is this the only thing holding him?
It's a municipal ordinance.
Oh, it's a municipal ordinance? Oh, then,
Sir, do you want to resolve your case today?
Yes, ma'am.
Okay, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, I do.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any alcohol or drugs today?
No, ma'am.
Have you ever been treated for a mental or emotional illness which would impair your ability to understand what's going on?
No, ma'am.
Do you understand you're waiving your right to an attorney and to trial?
Yes, ma'am.
All right, sir, and you're pleading no contest to the municipal ordinance? Is that correct?
Yes, ma'am.
I accept your plea. I find it is freely and voluntarily given. The court will withhold adjudication, take judicial notice of time served, and you'll have 12 months to pay your court costs.
Thank you, Your Honor.
All right, good luck. John Paul Cohen?
Mr. Cohen's here, present. Judge at Maine, he is approaching.
Hello, sir. You're being held on a capias with regard to a petty theft, and the status is going to be set in the division that it's assigned. Do we know whose division this is going to?
I believe I think that's Judge Solomon.
Okay. Anything, State?
One moment, Your Honor. I don't know if Mr. Romero spoke to him about resolving that.
Judge, he's not interested in resolving his case. He's looking forward to his day in court. Judge, my concern is in speaking with Mr. Cohen, I asked him if he's going to be able to postpone. He doesn't think so. And right now, this case, I believe, is out of satellite. So I think this probably needs to be transferred to here, Central.
It's not, Your Honor. It originated in satellite. It was transferred. Matter of fact, according to this, Mr. Cowan failed to appear at a non-jury trial in front of Judge Solomon on the 21st, so she issued a $500 bond.
Okay. Anything else, Mr. Romero?
So Judge Solomon's here at Central, right?
Yes.
Okay, all right.
All right.
Thank you, Judge.
Okay. Alan Patrick Moskowitz? Hello, Mr. Moskowitz.
Yes. Good morning, Judge.
Hi. All right, so you're being held on 2 charges, disorderly conduct and resisting officer without violence.
Your Honor, I spoke with Mr. Reedy about this matter. I believe we're in agreement. We're going to ask that the court transfer Mr. Moskowitz's case to Judge Lerner Wren, the Mental Health Division. I checked, Mr. Moskowitz has been through that division in the past.
That is correct, Judge, and I've looked through Mr. Moskowitz's history with our office. We've represented him a number of times, and there are issues that do need to be addressed, especially in light of the language of the probable cause affidavit.
Okay, so the court's going to find probable cause with both charges, and we're going to transfer this case to Judge Lerner Wren.
Thank you, Judge.
Andrew Jackson Schuldman?
I've been advised he bonded, Judge.
Okay, thank you, Mr. Romero. Lucius John Favors?
I've been advised he bonded as well, Judge.
This one too?
Yep.
Danatorius Preston Finklin?
He's here, President Maine, Judge.
Hello, sir. You're
Judge,
being
he's
held
asking your Honor to
on a
consider resolving
capias
his case.
misdemeanor? State?
One moment, Your Honor.
One 7288 MM28.
Judge, I believe, Mr. Finklin, this was at a retail store. I believe merchandise was recovered, so there shouldn't be any outstanding restitution issues. And Mr. Finklin's advising me if Your Honor would consider resolving his case today.
Okay. All right, State?
Your Honor, the state is offering time served.
He does have criminal
Just to
history.
accept it.
Okay. Sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes,
Time
ma'am.
served.
Okay. Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Do you suffer from a mental or emotional disorder which would impair your ability to understand what's going on today?
No, ma'am. Not at all.
All right, so you understand you're waiving your right to trial, correct?
Yes, ma'am.
And sir, you're pleading no contest to the petty theft?
Yes, ma'am.
I accept your plea. I find it is freely and voluntarily given. The court will adjudicate you. to time served, and you'll have 12 months to pay the court costs.
Yes, ma'am. Thank you, Your Honor.
You're welcome. John Elliott Smith.
Mr. Smith is approaching, Judge. He's here at Maine.
Hello, sir. You're being charged with petty theft. State?
Your Honor, the state is asking for a bond increase to $500. The defendant has a prior grand theft, a pending threat, a grand theft, a pending other forged instrument, and unlawful use of false name and name identity.
Judge, normally on
And the
this type
pending
of-
grand theft is between $5,000 and $10,000.
Okay. All right, Mr. Romero.
Judge, normally I would ask you on this type of charge, since the nonviolent misdemeanor offense is considered an ROR, considering the circumstances of what the state has pointed out, I'd ask you at this time just to leave the standard bond in place of $100 on Mr. Smith's behalf.
Okay, the court's gonna go ahead and find probable cause, and we'll leave the standard bond. Ramon Gonzalez?
See what he's being held on? For the BCPS, okay.
Medical reset, Your Honor.
Medical reset.
Valentino Andrew McFarland?
He's in Conte, Judge.
How you doing, Mr. McFarland?
Yes.
Your Honor, this is just an ad charge. You saw Mr. McFarland, I believe on Monday, on a motion to release on a strong arm robbery. So he's being held on multiple other felony offenses, so we're just asking that the $1,000 bond be kept in place.
Okay. Anything, Mr. Reed?
No, Your Honor. I think he's probably going to be having a bond reduction hearing on all of his pending matters.
Okay, so the court will
Can
go
I also
ahead.
have a question?
Hold on one second, sir. The court's gonna find probable cause. The bond will be set at 1,000. And you can ask your question. I don't know if I can answer it.
Okay. I was concerned because Capias is missing court.
No, it's, Your Honor, it can be issued for missing court in this instance. The state filed an additional charge from what he was first arrested for. The clerk's office, upon filing that additional charge, the clerk's office issued a capias to ensure he.
So, Mr. Reedy, who's his attorney in your office?
I'm looking that up right now,
Hold
Judge.
on, sir. We're gonna make sure that you have, communications with your lawyer, okay?
Okay, because I was incarcerated first the time.
Right,
This
right.
is, this goes back to his original arrest. This isn't alleged to have occurred after he was in custody.
Okay.
Original arrest.
His attorney is Joseph Burke.
Okay, sir, what we're gonna do is Mr. Rady's gonna make sure that your attorney follows up with you, okay?
Okay.
All right, good luck.
Okay, thank you.
Ronnie Edward Jackson?
No, bro.
Hello, sir.
How you doing?
You're here, you're being charged with violation of probation felony, and you do have a hearing set on January 2nd at 9 a.m.
All
Okay.
right, thank you.
All right, sir, good luck. Eric Reyes?
Mr. Reyes is here present, Judge of Maine.
Hello, sir.
Good morning, Judge.
You're being charged with possession with intent to sell, manufacture, or deliver heroin. Number 6, distribution, deliver heroin. 7, distribute, deliver heroin. 8, distribute, deliver heroin. 9, distribute, deliver heroin. And 10, distribute, deliver heroin.
Judge, in speaking to Mr. Reyes, my understanding is he's been in custody for about 40 days. He's currently being held, from what he informed me, on a no bond VOP hold. So at this time, nothing to add from the defense, Judge.
Your Honor, the state requested the bonds be kept in place.
Okay, very good. The court does find probable cause on all counts, and we will keep the standard bond in place. Good luck, sir.
Thank you, Judge.
Michael Sean Smith?
Conte.
Conti?
Hello, Mr. Smith.
Morning.
Let's see, you're being charged with probation violation, another probation violation or community control, another probation violation or community control, and also grand theft. Sir, you do have a hearing scheduled for January 2nd at 8:45 a.m.
Right.
Anything from the state?
Your Honor, the state requests that the bonds be kept in place.
Mr. Reedy?
That's fine, Judge. He has to go in front of his division judge.
Okay, so the court does
So
find
these-
probable cause, and we will keep the standard bonds in place. And sir, you'll be able to address your case in front of your assigned judge on January 2nd at 8:45.
Can I ask a question?
Yes.
Are these the same charges, right?
State?
I'm sorry.
State?
Your Honor,
Hello?
the state is requesting that the bond be kept in place.
No, he has a question about the charges.
Oh,
What is?
Can you repeat that, sir?
I turned myself in cause of the violation, and I'm just wondering, is this the same thing they're going over that I go to
No.
court for? Or
Let me see that. No, Your Honor, the reason for, all right. Through an open investigation, law enforcement determined this alleged grand theft occurred on October 16th. Counts 4 through 6, he's being charged with violations of probation under Florida Statute 94806, which is a warrantless arrest. Based on the alleged new law offense, they're adding these additional counts of violation of probation.
Okay. All right, sir, good luck.
That's him.
all right, thank you.
Patrick Zatoli?
Mr. Zatoli's from our main judge.
Hello, Mr. Zatoli. You're being charged with dealing in stolen property and false owner on items. State?
Your Honor, the defendant has a no bond hold with the Department of Corrections and will be going before Judge Calara on December 28th. The state is requesting that the bonds be kept in place.
Okay. The court does find probable cause with regard to charge 1. Bond will be set at $3,500. Number 2, bond will be set at $1,000. Good luck in front of Judge Calara, sir. Christopher Price?
Your Honor, we would waive formal reading of the charges against Mr. Price.
Okay.
He's here present, Judge.
State?
One moment, Your Honor. Oh, I got it. Your Honor, Your Honor, state is going to be requesting bonds in the amounts of $10,000 on each on counts 1 through 11. Additional conditions that Mr. Price have no contact with any minors, and that Mr. Price not be in possession of any devices that have internet access until further order of the court. This is based on the seriousness of these allegations, the strength of the evidence against Mr. Price, potential consequences he faces if convicted. Also noting, Your Honor, without going into great detail, the amount that was located allegedly by law enforcement is much greater than the charges he has been charged with, and there remains a possibility of additional counts.
Okay.
I'm just checking to see. I'm showing criminal history out of the state of Texas, 2008, fleeing a law enforcement officer, driving with invalid license, 2003, driving while intoxicated, 2003, out of the state of Texas, and evading arrest using a vehicle, 1999, out of Texas. Also, obviously noting that he has warrants for out-of-county holds, one for a failure to appear in court from Fowler County, or, I'm sorry, Monroe County. Nothing
Okay.
further.
Thank you. Mr. Romero?
Judge, he's been residing out here in South Florida for 7 months. He's been residing in the state of Florida for about 3.5 years. He relocated from Key West, came over here. He's currently living in Deerfield. He was seeking help or treatment at a halfway house. He's been there for about 6 months. Right now, the only person that could potentially post his bond are his parents. From what he advised me, they're retired. They reside in Texas. He obtained employment. He believes he probably already lost his job because he's here. But he's a cashier at a store making minimum wage, $8.10 an hour. From what the state has suggested, as far as I believe my math is correct, $110,000 is something way beyond Mr. Price's financial capability. Judge, we'd be asking you to consider setting a bond somewhere in the neighborhood of $2,500 on each count. I believe if my math is correct, that's going to be somewhere close to about $30,000. Maybe that's something that his parents can try and post on Mr. Price's behalf.
Okay, thank you, Mr. Romero. The court's gonna go ahead and find probable cause on all of the charges, 1 through 11. The court's gonna set bond at $10,000 each with regard to 12, 5,000, and 13, 2,000. Mr. Linder, what was the restriction?
Your Honor, that there be no contact with minors and that Mr. Price, until further order of the court, not be in possession of any devices that have internet access.
Okay, sir, you're not to have any contact with any minors pending further court order, and no access to any type of electronic device?
Yes, Judge.
Okay, all right, sir. Jamal Wilson?
He's here, President Main, Judge.
Hello, sir. You're being charged with failure to stop and remain at an accident involving non-serious injury and leaving scene crash involving damage to property.
Does he have priors? 1 moment, Your Honor. You tell me what it is about your bond. You read through it. It's a felony offense. He broke a bike driver's ankle. It's for $1,500. Let's see what she does. And see, there's concern about his future appearance since based on the nature of the allegation.
Your Honor, the state is requesting a bond in an amount of $1,500. There is a concern that for a concern whether he will show up based on the nature of the allegations.
And, Your Honor, just without going into detail, and I believe pretrial could provide his DJJ paperwork if you want to see the details, but he does have juvenile priors involving violence and dangerous offenses.
Okay, let's hear from Mr. Romero.
Judge, and speaking of Mr. Wilson, he's 18 years old, been living here his whole life. He's a senior at Hallandale High School, set to graduate this upcoming school year. He plans on walking on June 1st, his diploma. He just obtained employment. He's working at Flanagan's, making about $9 an hour. He lives with his mother in Hollywood. She is a hairdresser. We're not far off, Judge. We'd be asking you, I know this state, I believe, suggested $1,500. He believes that his mom can afford a $1,000 bond with the premium through a bondsman. So we'd be asking you to consider a $1,000 bond on Mr. Wilson's behalf.
Okay, sir, the court's gonna go ahead and find probable cause, and we're gonna set bond at 1,000. Didal Dorville?
Mr. Dorville has some family members here who may wish to address the court in reference to the family's financial resources.
Okay. Okay, hello. Okay, ma'am, please raise your right hand. Do you swear or affirm to tell the truth?
Swear.
Okay. All right, sir, you're being charged, let's see, charge 1 is burglary dwelling. Number 2, criminal mischief, 3, a capias, and 4, another capias. State?
1 moment, Your Honor. I just have to check something. I'm showing that Mr. Dorville has a pending affrays and disorderly conduct right now. Yeah, that's 3 and 4 before the court. So apparently, there's a failure to appear. Just trying to see if there's a, yeah. I'm showing that he's on juvenile probation right now. Yes, he's currently on juvenile probation, Your Honor, for a violent offense. Based on that, and this involving someone's home, I'm going to be asking for a $15,000 bond, no victim contact.
Okay, Mr. Romero?
Judge, right now, I believe his cousin's there. I don't know if Mr. Reedy had a chance to talk to her and see how much the family can afford as far as a bond. Mr. Dorville, he's currently going to school. He goes to H.D. Perry High School, which is located in Miramar. He's unemployed, so financially, he's going to be counting on his family to post his bond. So I don't know if the family, what's their financial resources as far as being able to post what the state is suggesting of that $15,000 bond, or if they're going to be requesting maybe potentially a lower bond amount or something more reasonable. I don't know their financial situation, Judge.
All right, let's ask Mr. Reedy to assist.
Sure. Would you state your name, ma'am?
My name is Tiara Casimir.
And what's your relationship to Mr. Dorville?
I'm his older cousin.
His mother, as I understand it, would have been here today, but she has to work, is that correct?
That is correct.
And would you describe your family as a close-knit family?
We are very much.
Where would Mr. Dorville be living if he were released?
The address that you guys have on file for him, the 3586,
How long has he been living at that address?
since he was 3 years old.
And is what Mr. Romero said, he's in high school right now, or looking forward to graduating from school this semester?
That is correct.
Okay. And do you believe he will return to court when he's supposed to?
If I have to drag him, I will.
Okay, and you're going to be keeping an eye on him, is that right?
That's correct.
As far as finances are concerned, how much money do you think your family could put together to bond Mr. Dorville out of jail?
Unfortunately, we wouldn't even be able to do that at the moment.
Do you have any money at all to do it?
No.
If he was released on pretrial release, would you make sure that you got him back to court when he was supposed to be here?
Yes, I will.
Okay, but there's no financial resources at this point in time at all? Okay.
Hey, ma'am, I have a couple questions. Is Mr. Dorville graduating from high school?
Yes.
This semester? Has he been attending?
Yes, he has. He takes the early morning classes.
Okay.
Yeah.
And he's been attending school daily?
Yes, sir.
All right, the court's gonna go ahead and, you wanted to add something, Mr. Linder?
Your Honor, and I hear what his cousin's saying, but what I just can't help but think of is he's been residing there. Well, that means he was also residing there when he committed the offense that he's on juvenile probation for. That's where he was living when he committed this alleged offense, violating his probation. He was living there when he didn't appear for the case on counts 3 and 4. Your Honor, I understand that there's financial limitations, and I understand that's a factor to consider. But it has to be balanced with protecting the public. It's not just showing up in court, it's protecting the public. And while the fact that facing a potential violation of his probation on a violent offense didn't prevent him from allegedly committing this incident where he went onto someone's property, entered their property, and only didn't continue because the victim happened to be home and saw him doing this. I think the concern for the public outweighs the mitigating factor of their financial resources.
Okay, thank you, Mr. Linder. The court's gonna go ahead and find probable cause. With regard to the first charge, bond will be set at $7,500. Number 3 and 4 will keep the bond in place at $250 each. And sir, you're to have no contact with the victim, either direct or indirect. Do you understand?
Yes, Judge.
And you're to remain at least 500 feet from the victim until further court order. Do you understand that?
Yes, Judge.
Okay, and you're not to possess any firearms or ammunition, okay?
Yes, Judge.
Also, sir, you have a status, it's gonna be on January 8th at 2 p.m. Ms. Furman?
Mr. Furman is here present, Judge. We're gonna be requiring a Spanish interpreter.
Okay.
I believe that was my fault. I didn't call for one. But however, he advised me as private counsel, Mr. Armando Hernandez from Dade County, Judge.
Okay.
So I don't know if Hernandez was there. I figured he was gonna show up and call up his case.
We don't have anyone here by that name. Mr. Romero, is he able to get some assistance with calling his lawyer to see if they're coming?
Let me ask him if he has his phone number with him right now. Give it to me. I could try and maybe call him during lunchtime, and then we could put this on recall for this afternoon.
Okay,
So let me talk to him in a second.
Okay, all right.
I just ordered a Spanish interpreter, so let me know what you want to do.
Judge, he just told me that his wife has a phone number to his attorney. He knows his wife's phone number, so he's gonna give that to me. I can call her during lunchtime.
Perfect.
So maybe we could reset his case for this afternoon at 1:30.
Okay, we'll set this one back at 1:30.
I'm sorry, Mr. Reed.
Do we have anyone else over there who needs a Spanish interpreter, Mr. Romero?
No one else.
Okay, thank you.
I apologize, people.
Carlos Jarigi?
North Broad, Your Honor. He's approaching. Step on that, check it.
Hello, sir. You're being charged with purchasing heroin, drug paraphernalia, and probation of violation or community control. With regard to the violation of community control, sir, you have a hearing set on January 2nd at 8:45. State?
Your Honor, the state requests that the bond be kept in place since he has the probation violation.
Mr. Reedy?
I really don't think there's very much choice of what you can do, Judge. He's going to have to go in front of his judge on the 2nd.
Okay, sir, the court's gonna go ahead and find probable cause. We'll keep that bond at $3,500, and then you'll be before your assigned judge again on January 2nd at 8:45. Good luck. Blake Sterling Davis?
I think he might be a medical loan.
Okay. All right, you're correct, Mr. Reedy. Jarlene Theophilus DeVoe?
He's approaching, Judge.
Morning, sir. You're being charged with grand theft auto, driving with a suspended or revoked license, propelling a moped, and probation violation. And sir, you do have a hearing scheduled for that probation violation on January 9th at 8:30 a.m. State?
Your Honor, the state requests the bond be set in place considering the probation violation.
Mr. Romero?
Nothing to add, Judge.
Okay, the court does find probable cause, and the bond will remain in place at 1,000.
Good luck, sir.
Good luck at your next hearing. Brandon Lynn Tyson.
He's approaching.
Hello, sir. You're being charged with grand theft auto, fraud, uttering a false instrument, resisting officer, obstruction with violence, and 4, 5, and 6 probation violation or community control. You do have a hearing scheduled, sir, on December 26th at 9 a.m. with regard to the probation violation. State?
Your Honor, the state requests that the bond be set in place considering the probation violation.
Mr. Romero?
We'd be fine with the $1,000 bond on count 3, considering he has a no bond holds on counts 4, 5, and 6.
Okay, so the court's gonna go ahead and find probable cause, and will adopt the state's recommendations with the bond as well as the defense with regard to number 3 at 1,000. Okay, thank you. Jeremy Agenor?
He's here at Main, Judge?
Hello, sir. You're being charged with, possession with an intent to sell, manufacture, deliver cocaine, possession with intent to sell, manufacture, deliver cannabis, misuse of temporary tag to avoid registration, and operating without a valid license.
Your Honor, he has no priors.
Judge, it's being Mr. Agenor He's been here his whole life. He's 23 years old. He obtained employment about 5 months ago. He worked for a moving company. He makes about $13 an hour. At this time, he is living in Tamarack. He rents an apartment for about $500 per month. He doesn't have the financial ability to post bond. Judge, considering this is a nonviolent offense, we'd be asking you to consider releasing Mr. Agenor on pretrial release.
Okay, the court's gonna go ahead and find probable cause with regard to all the counts, and, we will release Mr. Agenor in pretrial release.
Thank you, Judge.
Terms and conditions of his release, Your Honor, is going to be a drug evaluation and random drug testing.
Okay, sir, you're also gonna be subject to a drug evaluation and random drug tests, where you're out on pretrial.
No problem.
What were you gonna say, Mr. Romero?
I was gonna say, he's presumed innocent on this case, so pretrial is,
That's the
some people
terms and
could see it as a
conditions of
type of
pretrial
probation,
release, Your Honor.
and now pretrial is recommending on their own as far as a drug eval and follow-up and all these conditions on a person who's presumed innocent. Unfortunately, he doesn't have the financial resources to post bond, or else he would have probably rather post bond. I believe there are costs associated also with this drug evaluation. So Judge, at this time, I'd ask you to consider straight pretrial release.
Your
Let
Honor,
me hear from Mr. Linder.
I don't believe the presumption of innocence can be a basis not to apply release conditions, because then, since everybody's innocent until proven guilty, there would never be release conditions on anyone.
All right, Mr. Romero, respectfully, my ruling is gonna stand. He's gonna be able to get out in pretrial release, okay?
I understand, Judge. Thank you.
Roosevelt Lee Bass?
He's here, Mr. Bass?
Same deal.
Hello, sir. You're being charged with petty theft in the second degree, third subsequent offense, false ID given to law enforcement officer. You also, sir, have a capias on a felony, and you have a status on that case on 12/27 at 8:45 a.m. State?
Your Honor, the state requests that the bond be set in place.
Considering the no bond hold, Judge, there's nothing to add from this time.
Okay, so the court's gonna go ahead and find probable cause, and the standard bond of the $750 will be in place, okay? Andre Medina Souza, Light?
Yes. Mr. Lacey is here present, Judge.
Hello. You're being charged with obtaining property over $2,000 by fraud, grand theft, fraud, money laundering, fraud, insurance fraud, misrepresentation on the payroll or workers' comp, fraud, uttering a false instrument, and lastly, number 7, engage contracting business without certification, first violation.
Your Honor, the state is going to be requesting that the courts keep the bonds that Judge Siegel set in place. Additionally, Your Honor, we are going to request that you also impose the special bond conditions that Judge Siegel set. And if the court is inclined to keep those special bond conditions, another reason for keeping the bonds in place is that one of the release conditions is a nebia requirement, where he would have to appear in front of his assigned judge anyways before he could be released, and that way a more thorough bond hearing if the defense wants to present additional mitigating information, the state can present witnesses.
Judge, what we'd be asking you for is to consider addressing on count 1 alone as far as a reduction in bond. The $125,000 bond associated with just count 1 alone is something beyond Mr. Lightay's financial ability. He's 50 years old, been residing in South Florida now for about 15 years. He's a plumber by trade. He lives in Coconut Creek with his wife. They've been married for about 10 years now, living at the same place for about 15 years. From what he advised me, his rent is about, or what he pays is about $666 per month. He owns a Toyota minivan. It's a 2013 vehicle with approximately 60,000 miles on it. He has, from what he advised me, right now no sort of money in the bank to try and afford anywhere close to the $125,000. Him and his wife is a waitress, support their 2 children, ages 7 and 12. Both are in public high school. Judge, we'd be asking you once again to consider on count 1 reducing it from $125,000 to $25,000. This is his first arrest. From what he advised me, he's a registered voter. He has strong ties to the community. He's going to be coming to every single one of his court dates. He's not a flight risk. He's going to be coming, Judge. So So that's what we'd be requesting at this time.
And Your Honor, just to advise the court, and just so the court gets a better understanding of why Judge Siegel set the bonds where he was, there is one allegation that between 2012 and 2016, Mr. Light, and through his plumbing company, submitted fraudulent billing to the city of Deerfield that allowed him to obtain payments totaling over $300,000.
Okay, so the court's gonna go ahead and find probable cause on all the charges. I'm not gonna interrupt Judge Siegel's bond amounts. With regard to the state's request for the special bond conditions, I'll allow Judge Siegel to handle that, okay?
Thank you,
Anything
Judge.
else, Mr. Romero?
Nothing else, Judge.
Douglas Rinker?
Mr. Rinker?
Hi, Mr. Rinker. You're being charged with possession of heroin. Charge 2, possession of cocaine. Charge 3, drug paraphernalia. And number 4, driving while license suspended. State?
One moment, Your Honor. Just mention.
Your Honor, the defendant has multiple priors, including a felony drug charge that he went to prison on. The state is requesting that the bond be kept in place.
Judge, and speaking to Rinker, he did advise me as far as his priors. I believe they're a little bit dated. I believe they're about over 10 years ago. From what he advised me, he's 57 years old, been residing in Broward County since 1983. He is employed. He's been working at the same place for apartment. It's called Villa P Apartment Complex, which is here in Broward County. He actually lives in the apartment complex as well. He's the handyman. Been there now for about 8 years. Unfortunately, there's no one that could help post his bond. His wife passed away about 4 years ago. He was honorably discharged from the Marine Corps. He served our country from 1978 through 1982. Judge, considering he has an address, this is a nonviolent offense. His priors are dated. We'd be asking you to consider releasing Mr. Rinker on pretrial release.
Okay, the court does find probable causes on all the counts, and we will release Mr. Rinker on pretrial release.
Thank you, Your Honor.
With random drug test and evaluation. Okay, Mr. Romero?
Judge, I believe it's pretrial that are making these suggestions. Judge,
On drug, Your Honor, on drug charges, those are the terms and conditions of release.
come on.
Or we can do
It's
that,
not-
or
it's
we
what
can
they
do it
want.
pending verification and have someone go out, verify with the apartment complex that yes, he does live there, and he can just sit here a couple more days until we verify his address.
And I also believe pretrial is allowed to make recommendations. I'm not aware of any rule or law that says they may not.
Judge, this is what's going on. In the grand scheme of things, it's like the state asks for something, we ask for something. This is a gentleman that's been arrested on a drug charge, presumably he's innocent. And now we have basically pretrial, who's employed by BSO, basically now saying, okay, now we want him drug tested. It just doesn't seem fair in the grand scheme of things. Judge, Your Honor made a decision. Your Honor imposed pretrial. State didn't ask for anything else, and now we have pretrial at the end saying, well, we want this added condition. It just.
Okay, I understand, Mr. Romero, but we're gonna go ahead and include that, okay?
Yes, Judge.
Marcus Levon Melvin? Hello, sir.
Good afternoon, Judge.
Okay, sir, you're being charged with dealing in stolen property. State?
$10,000.
Tell the priors and yes for standard bond.
Okay. Your Honor, the defendant has a prior robbery with a deadly weapon where he spent time in prison, 92 months. He also has a prior possession of cannabis, and a prior resistance without violence. The state is asking that the bond be kept in place.
Let's hear from you, Mr. Romero.
Judge, I believe the prior that they were referring to where he served prison, I believe Mr. Melvin got released in 2006 from prison. I believe his last contact with the system was in 2011. So this is almost, he's been 5 years or 6 years without any sort of incident. He's 34 years old. He just obtained employment. He works at a cafe in Tamarack. He's a cook. He's making about $15 an hour. Unfortunately, he did suffer a car accident on November 3rd. He was employed due to that accident and the side effects. He lost his employment, lost his type of residence. At this time, he happens to be homeless. He's trying to get back on his feet, and now he did obtain employment. He's on the way of getting back on his feet. There's no way he's going to be able to afford the $3,500 bond. Judge, he's asking, Your Honor, if you would consider releasing him ROR or on the alternative standard pretrial.
Okay, sir, the court's gonna go ahead and find probable cause and release you on standard pretrial.
Thank you, Judge.
Where's he gonna be living, Your Honor? We need an address.
Mr. Romero,
Like I said, Judge, and I don't know if pretrial, like, you'll have one? I have one today. You don't have one today? I have one today. Do you know the address?
Yes, I'll either have my grandmother's address on file, or I'll have my father's address on file this afternoon.
Judge, from my, speaking to Mr. Melvin, he said he does have members of his family that live in the community, that he has basically 2 addresses available to him that will allow him to live with him. I believe he said his father and uncle.
Your
Yes.
Honor, we'll just ask that he provide, upon reporting to pretrial, that he'll provide us with the address where he'll be residing. Per what he gave us this morning when we interviewed him for a possible
Okay.
release, he advised that for the past 2 years, he's been living in various shelters and hotels. We also contact his mom, who resides in Port St. Lucie. Mom advised she does not know where he lives.
okay, all right, so we have the father that's helping him out, Mr. Romero?
Tell him I'll have my father's address on file this afternoon.
He said he'll be able to provide, as pretrial suggested, the address when he goes to report to pretrial. He'll give him the address.
Okay, all right.
Thank you, Judge. Thank you.
Valerie Podolsky?
Sir, there's nothing we can do. No bond key, because she can't touch you.
Hello, sir. You're being charged with, number 1, possession of heroin, 2, KP's felony, 3, KP's felony, 4, KP's felony, 5, KP's felony, 6, KP's felony, 7, KP's felony, and 8, KP's felony. Sir, you have a hearing scheduled with your judge on January 3rd at 2 p.m. State anything?
Your Honor, the state requests that the bonds be kept in place.
Nothing from the.
Right, okay, the court does find probable cause, we will keep the bonds in place, and, you'll be meeting with your judge on January 3rd. Terry DeShields?
He's in North Broward, Judge. He indicated to me that if the court was inclined to leave the bonds where they are, he'll be able to bond out.
Okay. Good morning, sir. You're being charged with illegal use of a credit card. Number 2, fraud and misrepresentation. 3, possession counterfeit driver's license or ID. Number 4, possession counterfeit driver's license or ID. 5, possess counterfeit driver's license or ID. It's on my understanding that you'll be able to make the bond that's put in place. The court does find probable cause. State anything?
If he's gonna post the standard bonds, that's fine with us.
Your Honor, if he's gonna post the standard bonds, then that's fine.
Okay, sir. So you're gonna have to, for number 1, bond is set at 1,000. Number 2, it's set at 1,000. 3, 1,000. 4, 1,000, and the last charge 5, $1,000 bond. Thomas Cabrera.
I've been informed it's a medical reset, Judge.
Okay. Robert Charles Abel.
Mr. Abel is approaching Judge. Judge, he did decline to serve as a public defender, but as a friend of the court, he believes his family may have posted his bond. He's inquiring to see if his bond's been posted.
Let's find out. Can we check if this Mr. Abel's bond's been posted?
Yes.
They're gonna check for us, hold on.
When I log in, it cuts off.
It's being posted? Okay, good news, sir. The court does find probable cause, bond set at 1,000, and it's currently being posted, okay? All right.
Thank you.
You're welcome.
You see, watch when I do it. When I do this.
There must be something open somewhere. Hit reset the computer. Bottom left. No.
Crispin Bethel?
He's here, President Maine.
Hello, sir. Let's see. You're being held on 8 charges. Number 1, burglary with assault or battery.
And Your Honor, I believe that was misbooked. I'm looking at the first probable cause affidavit, and the officer put in actually a different subsection. He put in 4A, but it got booked as 2A. It
Okay.
should just be burglary.
Okay, just burglary?
Yes.
Sorry about that, sir. All right, so it's number 1, burglary, 2, grand theft, 3, criminal mischief, 4, burglary dwelling or structure, 5, grand theft, 6, grand theft, 7, grand theft, 8, grand theft.
Your Honor, on count 4, he's charged with armed burglary on the second probable cause affidavit pursuant to Florida statute 810.02 B. Burglary is a felony of the first degree, punishable by imprisonment for a term of years not exceeding life imprisonment. If in the course of committing the offense, the offender is or becomes armed within the dwelling, structure, or conveyance with explosives or a dangerous weapon. Your Honor, the probable cause affidavit is very specific and very detailed, alleging that in the course of the burglary, Mr. Bethel armed himself with.
Yeah, I don't have it.
Okay, here, let me just.
I got the other one, I didn't get this.
Yeah. It's unusual. I just want to see which word name. It's on this. Placing the business owner's firearm and ammunition in the pile of dog food that he also placed on the victim's desk. Your Honor, noting as far as the state would argue for first appearance purposes, there is proof evident or presumption great. Noted not only that law enforcement collected physical evidence that resulted in a DNA match for Mr. Bethel from the scene, but also that once arrested, Mr. Bethel provided a full detailed post-Miranda confession to the offense. Your Honor, state would be seeking a no bond hold on count 4, noting my concern being that in addition to this, it's alleged that just 3 weeks prior to this incident, he broke into a different automobile business, committed a burglary of that business. In this instance, in addition to the allegations I named, he stole a safe that contained $50,000 personal checks, $7,500 cash, and $8,500 in cashier's checks, 10 sets of keys to Jeeps, 2 keys per set, so another $4,000 in property. Just the amount of the monetary value of the property he's alleged to have stolen is so great that I believe he poses a significant risk to the community or property of the community, Your Honors.
I've got just one moment, Judge.
Of course.
I got one probable cause affidavit, but I did not get this one.
And Your Honor, just very briefly, while Mr. Reedy's reviewing, without going into specific detail, Mr. Bethel does have a history as a juvenile of committing violent theft-related offenses.
is your recommended bond for number one?
Well, I think Mr. Romero might be in a better position to give us information on that charge. But as far as the state's request for proof, evidence, presumption, great. First of all, from a probable cause standpoint, while I believe the statute allows for someone to be charged in this fashion for arming themselves during the commission of a burglary, it's unclear that Mr. Bethel actually left the place with the firearm. It looks like he left it in the pile of dog food. And I'm not saying that that's not probable cause still to establish armed burglary, because I think if you arm yourself while you're inside, I think that meets the criteria. But it's certainly something that the court can take into consideration when it comes to bond in this case. Our position would be that the state is asking the court to find Mr. Bethel, to find proof, evidence, presumption great on count 4. We would disagree. That is the highest criminal standard that we have in this country. It's higher than proof beyond and to the exclusion of every reasonable doubt. Mr. Bethel is presumed innocent. The statement that he gave does not indicate that he removed the firearm from the dwelling. Or business, is it a business? Business. So in that sense, I don't believe proof, evidence, presumption great is established. Furthermore, the state has only introduced a probable cause affidavit. If Mr. Bethel gave a statement, the state has not played that statement for the court to assist the court in making that determination of proof, evidence, presumption great. All they've done is introduced a probable cause affidavit, which is specifically designed for the finding of probable cause, perhaps one of the lowest standards that we have in the criminal justice system. They've called no witnesses, they've introduced no evidence, and we would ask the court not to find proof, evidence, presumption great on count 4 and set bond for Mr. Bethel.
Okay, thank you. Mr. Linder, what was your recommendation with charge number 1?
With count number 1, Your Honor, based on the totality of the allegations, I'd be requesting a $10,000 bond on count 1, the standard bonds on the remaining counts, and obviously I made my argument on count 4.
Judge, in speaking with Mr. Bethel, he's 21 years old, been residing here his whole entire life. He's currently employed. He works at a restaurant called Lobster Bar. He's a chef over there. He's been working there for about 6 months, making approximately $11 an hour. He lives in Fort Lauderdale with his mother. They share all the expenses. The apartment they've been renting now for about 3 years. Their monthly just rent alone is about $1,000 per month. Judge, he's advising me that financially his mom works at a hotel. She's in the cleaning department. There's no way that she's going to be able to post such a high bond. What we'd be asking you to consider, Judge, is on count 1, a bond of about he just doesn't know how much his mom can afford. His fear is also because he's not going to, if she can't afford to post bond, he's not going to be working in a way. His mom's going to basically lose the apartment. That's what's worrying Mr. Bethel tremendously. Judge, at this time I'd ask you to take that into consideration in determining a reasonable bond on Mr. Bethel's behalf. So we'd be asking for a $2,000 bond on count 1. And Your Honor, if I don't know if Your Honor is ready for me to make a recommendation on count 4.
Yes, I am.
Judge, we'd be asking you also, if Your Honor hasn't found proof, evidence, presumption great, Judge, we'd also be asking you to consider setting a bond somewhere in the neighborhood of $2,000 on count 4 as well.
Okay. All right, sir, the court's going to go ahead and find probable cause with regard to charge number 1. Bond will be set at $10,000. Charge number 2, bond will be set at $5,000. 3, bond will be set at $500. With regard to number 4, bond will be set at $10,000. Number 5, bond will be set at $1,000. 6, $1,000. For number 7, $1,000. 8, $1,000. Are you asking for
I'm sorry?
supervision? If
Yeah,
you reach bond?
Your Honor, reading my mind, because I didn't make the request because I was asking for a no bond on count 4. Now that the court has set a bond on count 4, I would ask additionally, should he post his bond pre-trial release with a GPS monitor?
And the court will grant that
Thank you.
request.
If he works, I'm fine with that.
Yes. Hello, Mr. Morse.
Your Honor,
Hi.
it's good to see you this morning. How's things?
It's good to see you too.
Good, good. I'm here on a friend's case. It's his name is Robert Abel. I think that's the young man sitting there in the The right-hand side, is that him?
I'll take this one.
Just bear with me one moment. I
Sure.
need to pull up the paperwork again.
I thought it was the next case.
Okay. I think what we're trying to do pre-trial release.
Oh, we already did. Oh, I'm sorry, maybe
We
I
did
was
it?
wrong.
Oh.
Michelle, did the family say they were posting bond on that one? Abel, was it pretrial or? I'm sorry, When I saw
Hold on,
it here, I
Mr.
thought we
Morris.
had-
Sure.
What one? I believe he bonded out.
He's already on bond?
Yes,
Thank you.
thank you. It's always a pleasure to see you.
Judge, it's good to see you this morning, too. Eric told me maybe it would be up next, so. No.
Thomas Cabrera? Oh, that's medical.
Judge, Mr. Cabrera, medical reset?
Okay. Deshaun Anthony Lewis?
Have a great holiday, Judge. Good seeing
Okay,
you.
nice seeing you.
Mr. Lewis bonded?
Oh, he bonded? Okay, thank you. Lavon Gibbs?
That's a medical reset, Judge.
Hey there, yeah, this is, he has no problem.
Stephen Ordo?
He's here, present, Judge. He declined to serve as a public defender.
Okay, hello, sir. You're being charged with possession of cannabis over 20 grams and drug paraphernalia.
Yes, ma'am.
Okay, and you're declining the services of the public defender today?
This is correct, ma'am.
Okay, let's hear from the state.
He has no history. Michelle, do you have any history on him? He doesn't live in Broward. No, Ordo. Yeah, but does he? Yes, please.
See, seems like nothing on it.
What's that?
This is Gordon.
Yeah, no, what county it's from? It's from Wilmington, Florida.
2015, he was convicted on a traffic offense, on an expired tag.
Your Honor, we would
2007, he was convicted for, it says vehicle approaching.
Your Honor, we would just be requesting that the $1,000 bond be kept in place.
Sir? Excuse me, Mr. Ordo, can you make that bond?
Yes, if I have access to my telephone at the bare minimum.
I have,
I don't have anybody, I have nobody that I can call, ma'am. I'm all on my own.
I
I'm
have
down
no,
here.
Okay, hold on, we're gonna,
Who's talking?
Mr. Linder, the
that's what I
state
thought when I saw
attorney,
Wilmington.
and we're gonna
I
try to
have-
come up
Is it
with.
my turn?
Sir, you're asking about your phone, and Mr. Linder is trying to answer you, okay?
I'm sorry.
All
That's
right.
fine.
I have no objection to BSO giving him access to his phone so he can get numbers to call.
Okay, so, we're gonna allow BSO to give you access to the phone, so you can call your friends, okay?
As a friend of the court, I'll draft that order, Judge.
Thank you,
Okay,
Mr.
all right,
Reedy.
so Mr. Reedy's gonna help you out as a friend of the court. The court's gonna go ahead and find probable cause, and bond will remain at 1,000, okay?
Thank you. Thank you very much.
All right, no problem. Jeremy Blake Bonovicino?
Medical reset, bro.
Mr. Brown?
He's here.
Hello, sir.
Your Honor, Mr. Brown, when he was originally arrested, he was arrested on 2 counts of attempted first-degree murder. Judge Benson ordered him to be held no bond on both counts. On one of the counts, it seems that one of the alleged victims succumbed to his or her injuries, and the charge was upfiled to murder in the second degree. I spoke with Mr. Reedy about this earlier. Ryan?
Yes, that's correct, Judge. I imagine that the state is going to be seeking to have Mr. Brown held no bond. He's already being held no bond on count 2, so we'd be reserving any argument as far as proof evident presumption grade is concerned. Mr. Brown is represented by Assistant Public Defender David Wheeler, and I will be contacting Mr. Wheeler to let him know of the developments this morning.
Okay.
And yes, Your Honor, because the change of charge went from 1P punishable by life offense to another one, we're just asking that the no bond be placed back on this count.
Okay. All right, sir, the court's gonna go ahead and find, and accept the state's request for no bond. Anything else that you need from me?
Nothing at this time, Your Honor.
Okay. Anything else, Mr. Reedy?
Not as far as Mr. Brown is concerned, Judge.
Okay.
I think that's it. Bonded.
Correct.
System off?